morning. So great to see a full room and to say hi to everyone. On behalf of the Ron Brown Center for Civil Rights and the Criminal Law Society, I want to thank you for joining us today. My name is Elaine Chu, and I am the director of the Ron Brown Center, along with my colleague, Professor Rosa Costello. First, just a few logistical reminders. As we've been advertising, this event is being recorded. It's also being live streamed. We've learned so much about how to do that with the pandemic. We're going to have students passing around some handheld mics to take questions from the floor. We've got ceiling mics, lapel mics. So I think our sound quality is going to be great today. Second, we have planned for close to a 2-hour discussion today with our special guests. But in the middle, from 11:25 to 11:35, around there, we're going to take a 10-minute intermission. And the reason for the intermission is just to allow those of you in the audience to leave early and perhaps allow others to join us late. We do have some conflicting schedules with classes, so that's what we decided to do. And then finally, let me just do a couple of thank yous. First, I want to thank Professor Costello, who had the brilliant idea last spring of inviting folks who were a part of the People versus George Bell case to our school. I want to thank our co-host, the Criminal Law Society, and our co-sponsors, the Coalition for Social Justice and the Journal of Civil Rights and Economic Development. The journal later this year is planning to publish an issue that will include a written transcript of our discussions today. I also want to thank Dean Michael Simons for his support and leadership. And I want to thank our team at the Ron Brown Center, Rebecca Pasternak, Christine Kalasar, and Kalia Lee. And finally, to all of the helpers at the law school, special events, marketing, IT, we can't do this without you. This event is such an important event for our community. Last spring, our community was shaken to its core when we discovered that one of the people who was privileged to stand in the front of the room, in the front of the classroom, teaching our students, had contributed to a constitutional injustice that took away more than 25 years from the lives of 3 New Yorkers. Outrage, upset, deep disappointment, anger, sadness. Those were our range of emotions. Today is a step that we take together to try and sort out these emotions, but perhaps more importantly, to grow and evolve in our vision of justice, in our understandings of the current systems in place, and the reality of racism and injustice, and our acknowledgement of the roles and responsibilities of lawyers, law professors, and students. Join me today in this incredible event. We're going to start with a brief welcome from our dean, Dean Michael Simons, and then we're going to turn it over to our special guests. You should have in front of you a flyer that really features just a brief summary of their bios. And so we're not going to do anything more than really introduce their names and have them share their stories. Thanks so much. Dean?
Thank you, Elaine. So Professor Chu thanked a lot of the individual people involved in making this happen, and there's a lot of people required to pull off something like this. I want to add my thanks to the Ron Brown Center and the Criminal Law Society for sponsoring this, and to JCRED and the Coalition for Social Justice. Ron Brown and Criminal Law Society for planning it, and JCRED and the Coalition for co-sponsoring. And I want to thank our panelists for being here. I'll also add, there's a whole bunch of 1Ls, and it's great. I know that there's a break at 11:25 to 11:35. I know some of you have class that starts at 11:10. Don't worry about getting up to go when you have to go. It's great. It's great that you're here, and come back whenever you can. So the title of today's event, Long Road to Justice, well captures 2 things. First, how long it took for justice in this case, 24 years, but also the way in which the road to justice, or maybe it should be the road towards justice, like, if you will, the arc of the moral universe, is an ongoing and perpetual one. So it was justice when George Bell, Rohan Bolt, and Gary Johnson were released. But that doesn't mean that justice, like with a capital J, has been achieved. As you know from your studies, justice and injustice results from a system. That's why we talk about the justice system. That's why we talk about systemic injustice. And that's why the work of dismantling systemic injustice is so important and unending. And what's wonderful about this panel is not just that we have a chance to explore the injustices of this case with experts, but that we're hearing from the actual individuals whose work made a difference. Our panelists today are living embodiments of a core principle of systemic change, and that is individuals and individual actions make a difference. So at the individual case level, it was the work of these individuals, these lawyers and investigators, that resulted in the overturning of an unjust conviction and the release of 3 unjustly incarcerated men. But their work did more than that, right? It was the work of these lawyers and investigators that helped bring to light the misconduct that was part of a system that allowed the injustice to happen. And that's how systemic change happens. And to give one small, but to us important, concrete example of that, the work of these lawyers and investigators led directly to changes here at St. John's. And Professor Chu alluded to it. For the one else who were not here, I'll be direct about it. One of the prosecutors in this case, who was found to have committed misconduct, Brad Leventhal, had been teaching evidence at St. John's for several years and was teaching last semester. And so the most immediate change, at least for me, that happened was I found myself back in the classroom teaching evidence in the middle of last semester, which I hadn't done in a long time. But more importantly, it prompted a needed institutional examination of our adjunct faculty and our coaching ranks, as well as a fresh look at our curriculum, the development of new courses, including a course on professional responsibility and the practice of criminal law, and a rethinking of and investment of resources in our criminal defense clinic. Now, in the overall scheme of things, in the context of the vast apparatus of the criminal legal system, those may seem like small changes, but they are changes to a system, right? No one likes to think of themselves as part of a system, but just as the law is a system, just as the criminal legal process is a system, legal education is a system. St. John's Law is a system. And those changes are systematic change. And that happens not because systems somehow just change on their own. It happens because of the actions of individuals. In this case, individual lawyers and investigators, these lawyers and investigators. And here's what's inspiring about that, and what I invite you to reflect on as you listen to the story of how this happened. This is a window into what you can do, into the difference you can make, and how you, as an individual with a law license, can bring about systemic change. So thank you very much for what you've done and for being here to share that with us today. I'll turn things back over to Professor Chu, who's going to moderate the first panel.
Thanks. So I don't know if you guys can read the print on their name tags, but just quickly going from that end to this end, we have Charlie Linehan, an investigator in this case, David Crow, one of the several attorneys on this case, Jabbar Collins, who joins us as someone who himself has had a journey and a long road to little j justice, and we'll be sharing some of his insights. Rita Dave, a second attorney, also on the attorney team here, and Pete Fiorello, who is a member of the NYPD, who joins us as really an instrumental part of how a lot of this came together as well. And so without any further introduction, I thought I'd start with a question to all of them about themselves, and if they could share with us the most relevant parts of their background, their lived experiences, their career, to just kind of help us understand the discussions that we're going to have today. And then if they could also address how they themselves became involved in the case, what drew them to the case, and what roles they played. So.
Sure, why don't I begin? Hopefully everyone can hear me through my mask. This is one of my few public events. I'm glad to be out again. And things sound pretty good. So I'm David Crow, Legal Aid Society Criminal Appeals Bureau. Been working at Legal Aid in the post-conviction unit since 1984. I first became involved in wrongful conviction cases in the 1990s, around the same time that the DNA exonerations were first beginning to get underway, primarily through the Innocence Project. Of course, we had a vast number of cases which did not involve DNA. And the conventional wisdom at that time was simply that if you didn't have DNA, you would never get an exoneration. One of the attorneys in our office happened to inherit or happened to be assigned to a direct appeal of someone in Brooklyn that she became convinced was totally innocent, but there was no DNA. It was a simple one witness case. Was the witness telling the truth? And so over the next 3 or 4 years, it became sort of one of the first of the modern era reinvestigation cases where we looked into the backgrounds of the detectives, the background of the witnesses, did some re-interviews, presented all of that. None of it moved the needle. At that point, my colleague reached out to the New York Times, just a cold call to a columnist there at that time. His name was Bob Herbert, and said, Mr. Herbert, you know, you have a national platform. You're writing about issues of urban justice in America. You're not a crime reporter or a crime beat guy, but I just have this story that I have to share with you that took place in Brooklyn. And the columnist, Bob Herbert, read the transcripts over a weekend and said, you know, this case stinks, and I'm going to use my national platform to write 3 columns about it and to basically excoriate the sitting district attorney in Kings County, who was at that time running for re-election. So the first of those columns ran, and the next day, my colleague got a call from a new top assistant to the district attorney who said, can we talk? And over the next 6 months or so, we were actually able to get a resolution of the case, and our client walked out. For me, the most memorable moment of the case was that when we were bringing the client out, there was a lot of press, and the question for all of us was, how many more Jeffrey Blakes are there? And it's a question I literally never asked myself at that time. You know, I worked one case at a time, and I basically said, gosh, I don't know. Jeff Blake from Brooklyn, who had grown up and had been incarcerated in the 90s, said, there are a lot. And that was sort of a response that stayed with me over the years. And as I stayed in this world, I began to see that he knew a lot more than I did about it. The DNA cases were giving us a window, a sample, you know, cases where there happened to be DNA, how many mistakes were being made, a lot. And so it was our job to try to apply those to non-DNA cases, of which we've done probably a few dozen over the years. So that's an overall background. Legal Aid, I'll just be very brief at this point. Legal Aid represented George Bell, who ultimately became sort of the lead movant in this Queens case. We represented him on direct appeal. We got some new evidence. We filed a post-conviction motion, which did not succeed. We did a habeas corpus proceeding for him. And then at that point, after about 10 years, we sort of gave up and said, well, you know, we did everything we could, and we put the case into a giant wall of papers in our offices where it sits today. And so we were basically sitting at our desks going on to new things when I got a call. And so I think maybe I'll turn it over to Rita at that point to take it from there.
I guess I should start with the call and then work back on how I got into all of this. But David, Legal Aid had Bell, of course, before. I've represented, can you guys hear me okay? Sorry. I've represented Gary Johnson since 2012. I represented Gary since 2012. And that started because I received an email from his brother-in-law who had seen me on Channel 7 on an investigative story that Sarah Wallace did about another wrongful conviction case. And he begged me to look at the file and maybe I could help his brother. And if I couldn't, perhaps I could put him in the right direction. Not being able to say no ever, and having a very full plate, I nevertheless said yes, which then led me to meeting Pete Fiorillo, who was on his own quest and mission to exonerate these men. So first, let me fast forward to how David and I and all of us got involved. I had the case 9 years, and ultimately, we were all hoping for a new DA in Queens. In hoping for that new DA in Queens, we kept saying, we'll get there, there will be change. And Pete had gone over to a law firm, Mark Walensky at Wachtell Lipton, and asked them to get involved. Their involvement brought in Charlie, and it brought in legal aid. And somehow at the beginning of the pandemic, we formed a coalition from all different parts of the world, which led us to this exoneration. But I've been a lawyer for 30 years. And in 1996, just a few months before Bell, Bolt, and Johnson, I got involved in a case where someone very close to me was also falsely accused and wrongly on his way to being wrongly convicted. That was my first foray as a lawyer into seeing the injustices and the withholding of evidence. But because I'm not the type of person that sits back, I worked that case and literally overturned Brady violations as they were happening. That took me into a realm of seeing firsthand what does happen in our system. And I couldn't, as a lawyer, understand how that was even possible, which then led me to doing more wrongful conviction cases because I couldn't say no to people that didn't have the resources or the ability. And so I started working on these cases. By 2012, I met Jabbar, who had exonerated himself, and he had promised some friends that he would never forget them, and asked me, "Hey, Reed, you want to look at this file with me?" And did I say no? No, I said yes. And that's how we began. And then Jabbar and I have been working together for many, many years. And we continue to, and we have at least 4 pending pro bono cases. We have never learned to say no. And I think oftentimes the more you challenge, the more you fight, the more you uncover. As long as you have the strength to say, I'm not going to take the answer that you're giving me, you will always uncover things. May not be popular. It may cause you to be a target, which I have, but you don't stop. If you're looking for justice with the capital J, then you don't ever stop. But that's how we all got together. And then legal aid stepped in because they had already represented Bell. I then got involved in representing Bolt. So now I had Gary and Bolt. And then our team just got bigger, and we did investigations, and we had strategy sessions. And then we ultimately got to a point where we were able to exonerate the 3 guys. And I think that's,
I would just add to that, Rita, that a key link, I think, in the process here was a lawyer by the name of Tom Hoffman,
yes.
who's been in this space for decades. And truly, I think, among a group of people that really are extra focused on the fight for capital J justice, Tom Hoffman is a standalone guy, and he had been working for decades to defend a guy and get a guy out named Robert Majors that he thought had been wrongfully convicted and was wrongfully convicted. And in the course of his litigation with that case, he came across, there were some DD5s, which I don't know how many of you are familiar with the internal workings of the police department, but a DD5 is basically what they call a complaint follow-up report. And it's the most standard kind of paperwork that cops produce when they're investigating cases. And in our case, there were 2 or 3 DD5s that we had gotten, or that the lawyers originally had gotten, that were heavily redacted. And to make a long, twisty story much shorter, through a series of coincidental events, Tom Hoffman got his hands on these 3 DD5s and he read them and he went, oh my God, this will exonerate the guys on Bell, Bolt and Johnson. And he just knew, because this is a small community, sadly, but it's a small community fighting these cases. He knew who they were and how to get in touch with them. And he reached out to them, and that kind of kicked everything off at that point. And unfortunately for us, for my firm, QRI, Quest Research and Investigations, we didn't get involved until that point, because that's when Wachtell Lifton brought us in. So I just wanted to mention Tom's name. And just sort of also just wanted to sort of give a quick description of my background, because I think I'm a little different from everybody else here in terms of background, certainly not in terms of ideology. But I was a prosecutor in the Manhattan DA's office for 15 years, where I, of course, prosecuted criminals and put police officers and detectives on the stand to prove those cases. But I finished as deputy chief of the public corruption unit there for my last 5 years. And in the course of doing that work, I had the opportunity to investigate and prosecute corrupt police officers. And so, though I had gone into the job eyes wide open and certainly ran into my fair share of detectives when I was on the other side, who I thought there was a problem with their story, and I would end up dismissing cases like that, actually investigating those cases really opened my eyes. And so when I left, I was fortunate ultimately to land with Quest Research and Investigations, which does a healthy business in exoneration work. And I don't mean business in terms of it being very lucrative, but we work a ton of these cases. And it's one of the things that many of us love about the firm, which was started by my colleague, Luke Brindle Kim, who is here today and was also an investigator on this case. So I do a lot of exoneration work there, and Luke and I also have a law firm, Linehan and Brindle Kim, where we also handle these types of cases. So we try to find as many ways as possible to be involved in this. And the thing that was amazing about this case is we were brought in as investigators, but we were ultimately folded into the legal team and joined because we're obviously both lawyers, and we joined the legal strategy calls each week. And that's really what was the most unique thing about this case, was the eclectic nature of the team and the different perspectives that were brought to bear on solving this case. So with that being said, I'll turn it over to Jabbar.
Thank you. So my experience was somewhat different of getting involved in these cases. Hello, can you hear me? Okay, oh wait, good. Thanks, Dave. When I was 21 years old, I was wrongfully convicted of murder and sentenced to life in prison. And I spent the next 16 years of my life there educating myself and equipping myself with the skills that would ultimately have my conviction overturned. I was poor and I lived in a housing project in Williamsburg, Brooklyn. And I'm sure most of you are young, but the Williamsburg of today is not the Williamsburg of 1990, trust me. So at the time, a rich Hasidic Jewish landlord had been murdered while he was collecting rent in a local building. And the police began to investigate all of the young black men who lived in the nearby housing projects, because police had reports that the young black man had been stabbed twice in the back. I was ultimately implicated by an anonymous telephone call to the precinct, which we later would find out years later was originated from the true perpetrators to the crime. And I voluntarily went to the precinct. The police checked me. I didn't have any scars on my back. 4 witnesses, eyewitnesses to the crime, all viewed me in a lineup, and none of them identified me, and I was released. But 3 weeks later, detectives from the Brooklyn North Homicide Bureau would go ahead and fabricate a case and ultimately have me arrested. And I remember standing in the courtroom when that verdict came back, and I had never heard my mother scream the way she screamed. And I knew that my life was over at that point. And I made 2 decisions that day. The first decision was that I was going to repent and I was going to turn my life back to God, because I had grown up as a Christian, but after my dad died, and I kind of strayed off, and I never really turned back to God until that point. But the second decision I made was that I was going to be an attorney, because I never wanted to be in a position like that again, where I was powerless and someone else had total control over my life. Because when I was in the courtroom, they were talking with terms I couldn't understand, and everyone treated me as if I was a non-entity. And with my family sitting in the back in the courtroom and me being unable to defend myself, I said, never again. And I went back to Rikers Island absolutely dedicated, knowing that I had two choices. Either I would have my conviction overturned and be exonerated, or I would die in prison. So for me, there was no plan B. And I was fortunate enough while I was on Rikers Island to come across a book by F. Lee Bailey called The Defense Never Rests. And he said something that struck me. He said, no matter how brilliant the attorney, no matter how brilliant the strategy, if the attorney has not conducted an adequate factual investigation, then his defense is doomed to failure. And that struck me because the witnesses who were coming into the courtroom to testify against me, I had never seen them before. With one exception of a guy who I knew in passing from the neighborhood, I didn't know who these witnesses were. So when I went upstate, I began to focus my time on the New York Freedom of Information law and to learn every investigative method I can learn from prison. I didn't wear glasses. I have contacts on now, but I didn't wear glasses. But yet, within 6 months, of literally reading myself to sleep, I needed glasses. And I literally pursued the study of law in the same way a drowning man goes after air. And for the first 3 months, I did everything I could. I read what became my Bible was a book by Professor William Stansky, Case Analysis and Fundamentals of Legal Writing. And it provided me with the framework to read into and to interpret case law. And my focus, of course, was not only on criminal procedure, but also on post-conviction litigation and civil litigation relating to the criminal process. And I was very successful, and I began to win freedom of information law lawsuits, Article 78 petitions in New York, and I began to help other prisoners. And by 1999, I had amassed a huge deal of information about my case. And my appellate attorney, who had practiced for 30 years at that point, took a look at my brief and said, Jabbar, you know what, you actually know more about this issue than I do. I'm gonna let you write the brief and I'll just put my name on it. And within 3 weeks, my conviction was affirmed by the appellate division. Devastated. And then I had to make a decision whether or not, a few months later, whether I pursue a federal habeas corpus. And then at that time, Congress had just passed a new law that placed a 1-year time limitation on habeas petitions. So while I had a strong issue on a state level, my issues couldn't carry weight in federal court. So I had to make a strategic decision as to whether or not to go forward or to whether to allow that time to lapse and continue to investigate my case with the hopes that one day I would develop enough evidence to prove my innocence and to be exonerated. And I had to make that choice. And you see, after a defendant is convicted, after he loses his first appeal, there is no right to counsel. And I was in this unique situation where I didn't have access to an attorney, and most attorneys wouldn't provide you with legal advice because they weren't representing you and they didn't want to provide you with wrong advice and run the risk of being sued for malpractice or even, having a grievance filed against them. So I had to make these decisions on my own. But that's what I did. I continued to investigate my case, and I learned how to litigate 1983 cases, and I used 1983 cases and other civil lawsuits as discovery vehicles to gather information about my case. When I found out, for example, that probation records were confidential in the New York law, I found a way to circumvent that by going into federal court and subpoenaing those records where there was no probation privilege. And by 2006, I had compiled all of the evidence that I needed to prove that I had been falsely convicted. 435 pages worth of documents, absolutely conclusive affidavits, hands down a winner. And I submitted my motion with a lot of fanfare. The New York Times published a front page story about my case. And within 9 months, the judge summarily denied my motion, a state court judge without a hearing. I was devastated. And after I appealed to the appellate division, my case was denied again. And then I finally filed in federal court in the Eastern District in 2008. And the case lingered on for 2 years. And during that time period, despite all the evidence I had, the Court of Appeals had issued a new case dealing with the freedom of information law. And this kind of goes to what Rita said about being absolutely exhaustive with these cases, even if you've gone over it 101 times. By this time, I had hired 3 investigators. I had spent thousands of hours on my case. But I said, what do I have to lose? And I put in a FOIA request to the county clerk's office for what's called a material witness orders in my case. Material witness order is a court order that a prosecutor or defense attorney can obtain to get a reluctant witness to testify and bring him into court. Now, during my trial, the prosecutor had represented that all 3 of the witnesses who testified against me were good Samaritans, that they had absolutely no reason for testifying, and that the only reason they were in that courtroom was out of the goodness of their own heart. And what I discovered through the material witness process, through the material witness order, was that 2 weeks before my trial took place, one of the key witnesses in the case had ran from the prosecutor, had refused to testify, and they actually incarcerated him for 2 weeks and then finally forced him to testify. And in addition to that, I found out that one of the other key witnesses against me had been going through heroin withdrawal at the time when he was interrogated, that the prosecutors promised him that, that the detectives promised that if he would implicate me in the crime, they would allow him to get drug treatment and to make sure that his felony case went away. By the time, about a year later, that same witness had been on made work release, and the prosecutors had threatened that if he didn't testify at my trial, they would have his work release revoked and they would send him back to upstate prison, despite the fact that he had fully recanted his testimony and had told the prosecutors what the detectives had done to get him to sign that statement in the first place. And all of this was suppressed throughout my trial. One other witness who was on probation at the time of my trial, we found out that initially he had come forward seeking a reward in exchange for testimony in my case. And once he found out there was no reward, he flew to Puerto Rico. And the detectives and prosecutors in my case went to Puerto Rico and told him that if you come back to New York and testify, we'll make sure all your probation problems go away and you'll never have to deal with probation again. And this is what happened. So in 2008, my habeas petition was filed, and finally, me getting that extra document, that material witness order, was what really blew my case open. And the federal judge handling my case in the Eastern District ordered a hearing on the case. And the first witness testified and revealed that in addition to everything I've just outlined, prior to my trial, the prosecutor actually threatened to bash the witness over the head with the coffee table, or excuse me, with the coffee pot if he refused to testify. And that proved to be the last straw. The prosecutor was required to testify the next day, and rather than testify and subject himself to cross-examination, the district attorney's office threw in the towel. They consented to having my conviction vacated and my indictment dismissed. So I was released June 9th, 2010, and I began working at a law firm a week later, working for Joe Rudin, one of the brilliant, many brilliant attorneys I had the opportunity to work with. And Joel took me in, and I began to work on civil rights and other criminal cases in his office. And for me, people like David Crow, I would read his briefs. It was a pleasure getting to meet him in real life, because I would read his briefs and structure my legal arguments after David's briefs and Joe Rudin. And I got to meet Rita because Rita was general counsel to the Jeffrey Deskovic Foundation, that another exoneree who worked on these wrongful conviction cases. And I had a dear friend, Anthony Nwobi, who I had promised I would help. And at the time, Joel was too busy, and I pitched the case to Rita, and Rita helped. And we were successful, along with Tom Hoffman, of having my dear friend's conviction overturned. We did that ever since. So Rita was working on Gary's case for a long time, and she asked me to work with him. And the way that Rohan got involved was because a reporter from the Wall Street Journal, Sean Gardner, had written a story about my case, and him and I were friends, and he gave me a call and asked if we would consider representing Rohan Bolt. Now, I knew all three of the men from inside Greenhaven, and Rohan was the man who everyone in the prison knew that Rohan would sit in his cell and cry all day. That's how we knew Rohan. Everyone referred to him as the guy, oh yeah, Rohan, he's the guy who cries all day. And I had always wanted to help Rohan, but I was in a place with 2,200 men, every single one of which had legal problems. So I never had an opportunity to help him. So I jumped at the chance. And we were fortunate enough to represent both Rohan and Gary. And through the grace of God and Tom Hoffman with that incredible DD5, and with all of the other work, we were able to work a miracle. So that's my story. Thank you.
Press a button? No, okay, got it. Yeah, my name is Pete Fiorello. I'm a retired New York City detective. Retired in 1992. My career briefly was I spent 10 years, 15 years in Manhattan DA's office. 10 of those years I was the bodyguard, chauffeur, gopher for district attorneys Frank Hogan, Richard Q, and Robert Morgenthau for the last 7 years. Then I went to Queens Homicide. Worked a lot of homicides. We had over 2,000 in the time that I was there. I didn't do nearly the 2,000, but we did work cop homicides. I got into this case purely by accident. I never had any intention of touching any case where a police officer was killed. That was forbidden. And a series of coincidences led me to this thing. It all started out in Suffolk County, where my son-in-law, who was a cop there, was arrested and framed by the district attorney, Tom Spoda, the chief of police, Jimmy Burke, and the lieutenant, James Hickey. I think many of you people probably read the papers about that. I don't have to qualify that. They're all going to jail. So I got involved in that case, and that led me to my son-in-law going to jail. And he meets a disbarred lawyer up there who was arrested and who was also framed by the one-time governor of the state. And he's asking me to do favors. Can I check this? He's still working on his appeals. And he gives me a name to check. And name is Fezzer, but Detective Fezzer, but no, it wasn't Detective Fezzer when he gave it to me, it was Fezzer. So I go into the internet, I find a Detective Fezzer, which was not the Fezzer he was looking for, but it was a detective that was involved in this case. And that led me into reading about the case. And I read it going in with, these cops did a great job. I started reaching out, but then I start reading the cases. There's something's wrong here. I saw the tapes of George Bell, guilty, no question about it, but he wasn't guilty. And Gary Johnson, same thing. But Rohan Bolt had a problem here. This didn't make any sense. So I go to a detective that was involved in the case, and I'm asking him about Rohan Bolt, and he gets angry at me. Oh, you guys don't do anything for money. Meaning I was private eye at the time. I'm not getting any money. I'm just making an inquiry. This is not the way I was taught. How somebody killed a cop? Whoever killed the cop? Oh. It's such a convoluted story. The only thing that I wish that John Grisham or David Baldacci was sitting in the audience, because this thing is really a book, How I Get Here. Cutting to the chase, my biggest contribution, did I miss it, is that because I was doing things in Suffolk County, I learned of a lawyer by the name of Mark Walensky, who performed a miracle out there. He got a fellow by the name of Anthony Adone out of jail for killing a correction officer who was moonlighting in a bar. And I says, hey, this is my kind of a guy. I got to get in touch with him. Then when I do some research on him, I find that he's with Wachtell Lipton, where my old boss was of counsel, the former DA, Morgenthau. And I said, let me give it a try. So I called him on the phone and this and that. And I contacted him through Mr. Morgenthau's secretary. And then all of a sudden, one day, I get an email, we're taking the case. And that was it. That was my main contribution. They must have spent at least $2 million, at least. Charlie might know more about that. $2 million in the defense of these people, and probably more. Justice is not cheap. And if you don't have the bucks and the money, without Wachtell, Lipton, and all the other fine people, they'd still be in jail. There's no question about it. So that's how I got involved in the case. And it was just that just trying to, I mean, I have so much to tell that I get confused. I'm getting old too. But I probably would do better in a question and answer. You ask me a direct question, I give you an answer. But it is so complicated how I got there. I never had the intention. Some people give me a lot of credit. I don't know, just without the lawyers, good lawyers. And that would be it, but that's about it. That's the extent of what I did. These guys didn't do it. I knew they didn't do it. I gave this information to a ranking officer in the Queens DA's office, believing that I was doing them a favor. And to straighten this thing out before it got worse, totally reject it. And they had detectives visit my house. They told me to shut up, don't get involved, witnesses I was trying to get. And that was the end of it. So that's where we go. But I should have prepared better for it. Here you go. Any questions? I mean, I think I could answer them better than what I could.
Yeah, you got.
I haven't
Great.
learned to talk with this fast guy yet.
We're now going to take some questions from the floor. It's actually already 11:17, which just drives me bonkers, but we're going to have folks passing around Mike. So raise your hand if you have a question. Valerie will come to you. Let's try to take one or two. Okay, great. Professor Sovereign in the back row.
Just wanted you to get some exercise. My question is, why do you think it happened? Why were they convicted? Why wasn't the information that was required to be turned over?
Ken, may I? Sure. So I think there were a number of reasons. Number one, the prosecutors in this case had a strong desire to win a conviction. This was the murder of a cop. And as you know, these are some of the most egregious crimes, at least in the view of law enforcement. Secondly, they had an enormous amount of political pressure to secure convictions in these cases. This was Mayor Giuliani at the time, who was a hard-nosed, by the book mayor at the time. He went on television and he had announced that they had solved the case once George and Gary had been brought in, even though the police had really requested additional time to continue the investigation. So these prosecutors at the time weren't about to publicly embarrass the mayor by telling him, look, we may have gotten the wrong guys. So they made a decision that we were going to win at any cost. And then I think the third reason is human nature, at least in this side, that they were selfish and that they cared more about their career than they did the lives of these three poor Black guys who were from the neighborhood. That the conviction of a police officer and the pursuit of their own career advancement weighed more heavily than the lives of these three men.
Yeah, I mean, look, let's be very direct about this. The lives of these three men, in their view, were disposable. The prosecutors and the police detectives, it's true that Giuliani, we all know the Giuliani of today. Back then, he had just come to office on a record of being a real law and order guy. The city was a lot different back then, so he had a lot more leeway to do the things that he was doing. And he was a publicity hound. And as Jabbar pointed out, the detectives were not comfortable at that point because they knew they had confessions that were not very good. I don't think they realized exactly how bad they were, but they were not good. But Giuliani, it was 4 days before Christmas, and he wanted arrests, and he wanted to close the case by Christmas. And I can tell you from a law enforcement perspective, that is a recipe for the worst possible investigation, is putting a time limit of 4 days on a case like this. And as Jabbar said, it's especially important to the cops and the prosecutors because it was a cop that was killed. But the final thing that I would point out, and this, of course, troubles me a lot as a former prosecutor because, they're not all bad. But we had examples here, and unfortunately, what we saw in working this case is that there was a culture at the Queens DA's office, in particular, where you had the old guard that they were willing to get convictions no matter the cost. It was not particularly important to them if they put a few innocent guys in prison, so long as they got the bulk of the bad guys off the street. And I don't need to tell law students that that is, you know, the exact wrong way to go about it, particularly when you're a lawyer. Not excusing when cops do that kind of thing, but you know, you always think of there being a much higher standard and that the prosecutors are the gatekeepers and are preventing that kind of nonsense from going on in our system, because it's well known that a lot of detectives, unfortunately, and Pete will back this up, I think, sometimes have the attitude, hey, you do what you got to do to get the bad guy off the street. So if they think they've got the right guy, they're not too concerned about making sure they do it the right way. Well, the prosecutor is supposed to be there as the gatekeeper, making sure that doesn't happen and rejecting those cases and pushing the detectives to do their jobs well. And these guys, you know, this case is unique because it was proven and the judge actually articulated this on the record. These guys deliberately withheld evidence from the defense. And that's simply an outrage.
I think add to that the fact that the mindset of, well, if they didn't do this, they did something else. And we got the right guys, we did the perp walk, we're on TV, it's all done. And the prosecutors who win these cases get a pat on their back, they get promoted, they get bonuses, they rise to levels in society, outside of society.
They become law professors.
And they become professors and, you know, and
No.
And to the school's credit, not because you're here, Dean, but to the school's credit, in the 30 years that I'm a lawyer, seeing someone take a stance and have an accountability was incredible. Because Jabbar and I have always, over the years, said to each other, these changes are so darn incremental. When in our lifetime will there be a change? And so that occurred, and for that, we are grateful. But it's the win that's the problem.
That's right, and I didn't mean that as a knock against the law school, and I
No,
agree
yeah.
that the reaction in this particular case by St. John's was
Yes.
incredible.
Extraordinary.
Yes.
But all I meant was, yeah, you know, if you're a lawyer and a prosecutor and there's an opportunity to, you know, to teach, a lot of people would jump at that. And the way that you often get those jobs is by being a standout prosecutor with a fantastic conviction record, which is
Correct.
not the standard that we should be using to judge prosecutors.
True. That's very true. That's right. Because no one checks. How did you get there? What did you do?
They, when Rudy Giuliani got involved in this thing right from the get-go, they never had a chance because they were going to do everything in their power to gain, because that's where the promotions come from. And they were never going to change that. Then that big clown came in from Albany for the funeral, Pataki, and he really put a kibosh to it. There was no way in the world that they were going to change this. These poor guys were going to go down, and maybe they plead out or whatever, and they do 5 years or whatever, but they were absolutely innocent. You know, these weren't even guys that I could say as a detective, a former detective, well, they did something else, they deserved to go to jail. They were just totally innocent. And the system, the courts, even the federal courts, they denied them everything. The writ of habeas that George convinced me, that George Bell wrote, was fine. They should have passed muster. The judge that heard the case is known as a pro-defendant lawyer, but he just went out of his way to make sure that these guys wouldn't get relief. So the whole system is, I have no faith in it, by the way. But like I say, I'm 80 now, so I don't have to put up with this much longer. You young folks, oh, by the way, you're lawyers, you're gonna be. And, you know, Alan Dershowitz says something that I was surprised that he said it. Don't just think about becoming defense lawyers. Where you can make a difference is become prosecutors. That's where you're in the middle of it. Maybe you could change things, get things to go the right way.
I'm no fan of Alan Dershowitz, but I think that there's a lot of truth to that.
Well,
I think with that, I'm going to take our 10-minute intermission and everyone take 10 minutes and we'll move on to more great questions. Thank you.
Thank you.
were here for our first half, and some have joined us since. And for those who are just joining us, this is a wonderful opportunity. We are getting to hear from some of the key players in the People versus Bell case. Sorry, want people to see your name. And so we left off with a Q&A, and I do want to pick back up with that because I'm sure there are so many questions. I just want to turn over to our guests and ask if there's anything else you want to share about the case or, the justice system before we open it back up.
Sure. One of the things I wanted to share was that this was not the suppression. This was not the suppression of exculpatory material by one isolated or actually two isolated prosecutors. There was an entire appeals bureau that systematically suppressed this information from every appellate attorney who handled each of these three men's cases. So the Brady obligation to disclose exculpatory evidence doesn't end that trial, and any subsequent prosecutors have a continuing obligation to disclose the same material. So all of this material that we were able to uncover last year and this year, this should have been disclosed to them throughout all of their state court and federal court appeals. But instead, each one of those appellate prosecutors either failed to look for the evidence or never conducted a full investigation, and they continued the initial suppression from these trial prosecutors. So they have blood on their hands too.
And then add to that, the defense attorneys, add to that defense counsel who don't know what to look for, who maybe choose not to look for it, who need to quickly resolve a case and get a plea deal done, and who start off with the premise of, well, the majority are guilty, and so let me move this along. So you add that and you have a perfect mix where you have attorneys who are supposed to dispense justice and do right, and the only person that suffers is the defendant because he or she has not had a fair chance in court.
And I would add that one of the really striking things to me about this case was that George Bell was charged with death penalty level offense. And at that time, that triggered a whole different set of lawyers. Some of the best lawyers in the state, some of the best lawyers in the world were assigned to represent him. And his ultimate trial lawyer, Mitch Dinerstein, has been for 40 years one of the top lawyers in the state. And so George Bell received outstanding legal representation throughout his case, which is different from the average wrongful conviction case you get, where you see, as Rita was saying, a lot of shortcuts, a lot of resource problems, and maybe some problems with the lawyers also. And so for me, the lesson I drew was that if this kind of suppression could happen in George Bell's case, where some of the most ferocious defense lawyers in the state were on the other side, how much easier would it be to not turn over that evidence in your run-of-the-mill case, no press, no outstanding lawyers on the other side? And that really chilled me, to say nothing of the idea that the Queens District Attorney was actually seeking the death penalty, which we would hope would be a case where you would take every additional precaution. Right. So those were really stunning to me. But I do want to say something else, which may be a little different perspective from some of the other panelists, which was that the evidence that was suppressed in this case, evidence that members of a ultra-violent street gang had actually been the true perpetrators of the case. There were two unusual things in this case. One, that news actually leaked to the press at the time of the original trial. And the defense lawyer, Mitch, among others, read it in his daily news on his way to court. And he went to court and he said, I'm reading in the daily news that NYPD wants to reopen the investigation because they think these other guys might have been the real perpetrators. And that's what really set the stage, because that forced the prosecutors to come into court and give a specific on-the-record assurance to the judge that there was no truth to those rumors. They had no idea how it had gotten started. That's what put the prosecutors in the bind, which ultimately led to their unprecedented level of responsibility attributed to them by the 440 judge, Judge Zayas.
And in fact, they went after Mitch quite personally on the record as the trial wore on, because Mitch rightfully was pounding his fist on the desk saying, I know this evidence is out there and I'm asking for it specifically. And they kept doing what you do when you're a prosecutor, even when you legitimately don't have Brady. You send a form letter that says we're aware of our obligations, our continuing obligations under Brady, and we will disclose exculpatory evidence if and when we discover it. They knew it. I mean, that's what we proved during the home stretch on this case, is that they knew that they had that and they kept it from the defense. And not only did they suppress it, they continually got up there on the record and called Mitch Dinerstein despicable and made all kinds of character assassination. And the judge, as happens in our system frequently, just went along with what the people said without digging down at all. And that's one of the major injustices on this case.
And to Mitch's credit, he stood up for himself. Where it was not good, where he didn't look good, where it wasn't, the right thing to be quiet, he stood up, he spoke up, and he never gave up, even if they maligned his character. And that's what everyone should be doing. You should stand up for what you know is right, even if others are going to demean you for doing that. That's how you make changes, by standing up and speaking up and being the lone person out.
And that is really hard to do. Many of you are going to be out there trying cases in this system. And let me tell you, it is one of the hardest things in the world to stand up and say no to a judge or challenge a prosecutor on the record like that. It's extremely difficult. So it takes real personal courage to do that.
The worst that happens is you get carried out by court officers. You come back in.
Maybe locked
So,
up.
Maybe locked up, not for long, but it does happen.
One thing I learned about about prosecutors, and Mr. Q was a great prosecutor himself. He wasn't there long enough to say he was great. But Hogan was the gold standard. Morgenthau just seconded. I mean, these arguably the two greatest district attorneys in the history of this country, let alone the state. And the one thing the three of them did religiously is that when they got into the car, they picked up the newspaper. And that's the weapon. That's the thing they all respond to. Publicity, publicity, publicity. And the whole thing, that gets them aroused. Jimmy Breslin once said, you want to solve a murder case, put it on the front page of the Daily News. That's what gets them motivated. So when you go through your travels as a lawyer, remember, don't be shy of publicity. This law firm that took this case, Wartell, I mean, they must have spent, maybe Charles knows better, they must have spent billable hours, $3 million.
Not QRI, let me be clear.
What?
I mean, no, you're right that there were a ton of resources thrown at this case. And that was a point that I also wanted to make, is nobody should be sitting here thinking that this is the way these cases normally go. Many of them are solo practitioners trying to get people out, and they spend years with no money, and sometimes with firms like ours working pro bono, more often with a retired detective who has to just work by himself and will literally spend years while the guy sits in prison. So this is a wonderful success story, but it doesn't happen without Wachtell Lipton pouring a ton of money into it.
Without it, it would have been hard. I mean, we do it on our own, and we rope in our police friends and our detective friends and the retired ones who are willing to go and get us info and work behind the scenes. And, we put up the money, we've put up money for things that we know we need to get done, because that's the only way. There are no other resources. So I think that you need to remain focused and be tenacious, and then you use the media when you need to. But everyone has differing levels and thoughts on how we can do that without hurting the client. Sorry, I know you have questions.
No, I have a million questions, but I'm going to turn it over to our audience. And if we could pass around some mics.
Hi. So it's no secret that this school offers a lot of prosecutorial programming and as such produces a lot of prosecutors after graduation. I'm wondering what you all think that this school can and should do to ensure that they're not producing prosecutors who are going to engage in this type of misconduct.
Well, I'll jump in.
Jump in.
I think First, and this kind of touches on something that I was discussing with the professors at the break. I think too often, if you look around at the conviction integrity units, at least the way they started, and they've started to change for the better. I think Bryce Benjet from the Innocence Project being put in at Queens is a good example. But for too long, they've been manned by veteran prosecutors who have never had any experience outside the DA's office. And sometimes, in the case of Brooklyn, for instance, there was an article the other day about how the head of the CIU there actually tried one of the cases that's under review by his unit. Now, he's recused himself, but ask yourself how much influence he still wields over what happens with that case. So the point that I want to get to is that, the way that I think you address that, I mean, it's obviously important to train good prosecutors in law school, in my opinion. And send people out from here that have the right approach to the job. And I think the one way to do that is to bring in prosecutors, and they do exist, who have had experience working on the other side, whether it's in the DA's office, prosecuting corrupt cops as part of some kind of a corruption unit, or doing defense work on the outside, or doing exoneration work. I think it really is a question of finding the people, because yeah, it's very easy to look and say, oh, this guy has, 50 murder convictions. That used to be the standard. That's who you would want teaching the class. But I think what we're discovering is what you really want is the person that, had the murder convictions maybe, but also had a number of instances where they dismissed an indictment or decided not to go into the grand jury because they recognized that there were problems with the case and they investigated it. Or, that actually recognized that there were problems with the case and pursued that case until that cop went to jail or lost his job. So that's the way that I think that schools should be going about it, is being more diligent about finding the right people with prosecutorial backgrounds to teach students.
I think that's a difficult question, because I think much of the misconduct that we're discussing is tolerated on the tolerated on the executive level of the district attorney's office. So it depends on who the policymaker is. Many law students, I assume, when you graduate from law school, you may get a job in the district attorney's office. You may have huge law school debts to pay, and you really need this job. You're depending on this to pay off. And there's a strong culture of conformity in these offices. And many of the line prosecutors, which you will be if you go into the DA's office, don't have a great deal of discretion. They have supervisors who dictate policy, and they have bureau chiefs. So if there's this policy to conform, it places any young lawsuit prosecutor in the position of choosing whether or not he tries to buck the system and possibly risk getting fired and not having a job to pay his or her loans, or whether or not they stand up for themselves. So I think the ethics course that the dean recommended is a great start, but I believe that much of it has to be focused on the particular prosecutor's office, because no matter what training you get here, you're going to be thrust into a culture that pushes you to conform and to go along with whatever the office's policy is. So I think it's a very difficult thing that you could totally address at this level.
One
And
thing I
also-
just want to piggyback really quick is that the other problem is it's not just conforming with the people in the office, but when you're a young prosecutor, it is extremely difficult when you have a cop sitting across the desk from you on a narcotics team telling you that he made an observation that you think he could not have made, or you just have serious doubts about what he's telling you. At that age, when you're a junior prosecutor, it's the rare prosecutor who can stand up and say, I got a problem with this. You need to explain this to me better. Never mind the prosecutor who can get out in the street and go actually look at the location himself and satisfy himself that that was even possible. So Jabbar is right. The challenges internally are immense.
But this is all outside of when everyone becomes a lawyer. To add to that, I think it's more important within law school in those 3 years that you should hear real life stories and examples. And when I went to the street corner and I met the witness, what exactly took place? And what did the police officer do? If you don't hear the real world issues that come up, then you're not going to know really how to stand up to a lot of it once you start practicing. So I think that is much more it readies you to come out there because now you've heard stories of the buy and bust, of, in our case, 230 feet away is a witness. Did anyone go to look at it? I know Bryce Benjet called me one morning at 7 a.m. and he was biking to look at the scene. So as a prosecutor, you're busy, you're running around, but as a law student, while you're preparing, you should know the different types of things that you are going to be faced with so you can decide, how will I handle this if I'm faced with this? Will I stand up to the cop when I don't think he really saw what he saw? And I think that's important.
Hi, I wanted to ask Charles a question specifically. So I wasn't here sooner, but I wanted to know what made you not want to be a prosecutor anymore, or what happened with your changing career?
Well-
Being that prosecutors have so much power and everything.
Of course, yeah. To be perfectly frank, I had my second child. That was the primary reason. Look, I loved my time as a prosecutor. And part of that, quite frankly, the Manhattan DA's office, which has its own raft of problems in this space. Mr. Morgenthau was a true leader and a man that I always thought was really cared about justice. I thought, the moment when the Central Park 5 decision came down, I get choked up thinking about it because I was like a third-year prosecutor. I was doing, little misdemeanor cases, and I got, they emailed the decision around the office. And this was explosive news in the DA's office because that had been one of the biggest cases of all time. And Mr. Morgenthau had, found out that there was this guy, Mateus Reyes, inside who claimed responsibility. And he, against enormous internal pressure, ordered a reinvestigation of that case. And he put Nancy Ryan on the case, who at the time was the chief of the trial division and a brilliant woman. And she just dug down and spent a year, she and Peter Casolaro, reinvestigating that case and found that they had gotten it flat out wrong and that some of the biggest names in that office had been complicit in that. And Mr. Morgenthau always taught us that the only thing he said when you started in the office was do the right thing. And it was a very powerful instruction, and he followed it to a T. I'm not saying he never made mistakes, he did. So all of which is by way of saying, I loved my time there, but I was not blind to these sorts of problems and to, attorneys that for a while I respected, and then I realized they would take shortcuts or, not question cops strongly enough. And it was kind of that drove me in the direction of going into corruption. Because look, I grew up in this city and I was not unaware that on a police force this large, you're going to have bad apples. I have a lot of cops that I think are great people and fantastic. They do fantastic work, but I saw too often that cops were cutting corners because they thought, look, this is a bad dude, we got to get him off the street. And as a lawyer, that's completely offensive to you. But that, unfortunately, there is a subculture in the police department that has that view. So I didn't want to leave, but I wanted to do something about that. And so I joined public corruption and rose in the ranks and became deputy and was able to really direct a lot of the work that we were doing there. And that really opened my eyes. So, and sort of made me start to have misgivings about just being in the office at all. So it was a kind of combination of that. It was very definitely, Jabbar, I don't want to disillusion you, but the pay that you get as a DA barely enables you to pay your law school loan. So it was definitely, my wife is a public servant, so I needed to move, but it was also the idea that I wanted to get out of there and start working on some of these issues from the private side, because I felt like I had a lot of experience that I could bring to bear on these problems. And QRI, is a firm that prides itself on doing public interest work, not just in criminal justice, but environmental justice and various other and political justice. And so it was a fantastic opportunity for me. And then to be involved in this case where truly I was able to bring my experience working with cops and prosecuting cops to bear on helping to crack this case. It was an amazing opportunity. Thank you for the question.
For those of you asking questions, if you could say your name and your year in law school if you're a student. Thank you.
Hi, good morning. My name is Keitha Duhaney. I'm a 1L here, just started a month ago. I know that earlier it was said that the reason that this happened is because people were seeking promotions and they wanted media spotlight. And I know someone also mentioned that they felt like that the men's lives were disposable. Does anybody think that that disposability is due to racism in any way?
Absolutely. Go ahead, Jabbar.
Not directly. I don't think that when these prosecutors made the decision that we're going to that these guys will be the sacrificial lambs, it was because they were Black. It happened to be because I think class, because of necessity. And I think that the same thing would have happened if they were poor white people too. So I don't think it was strictly due to racism. I mean, it could be an underlying factor, but I think many times that when these decisions are made, it's policy, it's practice, and it's self-ambition. So I don't think it was directly tied to race, personally.
I would, I'm sorry to jump in again, but I think Jabbar is right that it probably wasn't overt racism. I think that there were almost certainly, as there almost always is in law enforcement, implicit biases that were at work. And I really have, of course, I want to believe that racism rarely plays a part, but as we sort of have started to grapple in a meaningful way with the Black Lives Matter movement, over the past year, I've done a lot of soul searching, and I started thinking about when we used to arraign defendants, when I used to arraign defendants as a young DA, and the process is you go into the arraignment courtroom and there's a stack of 150 cases, and you have to very quickly go through those cases and analyze them in the 10 minutes before court starts and decide what you're going to ask for bail. And you're sort of forced in this position where you're just looking for like indicators that you think matter for the bail argument. And to Jabbar's point about if these guys had been poor white guys, would it have been the same? Well, arguably no. I mean, arguably yes, it would have been the same. But I can imagine a situation where you have a poor white defendant who grew up, let's say, in Peter Cooper Village, which is a housing project, but it's not the Baruch houses. And his mother, is gainfully employed. His father is a part of the family. And he goes to a decent school in his neighborhood and does well. And then you have a Black student or a Black kid who grew up in the Baruch houses, who, his father's not in the picture and his mom is holding down 3 jobs, so she can't make it to arraignments. And he does bad in school, partially because the school is terrible. And you realize that when you're making arraignment arguments, those are non-racial factors that we often use to make an argument for why someone should be held in on bail, right? But those are really the results, in many cases, of systemic racism. Like the dad's not there because he's been forced into prison so many times that he can't hold it together. So, I'm just always careful to think about, well, let's really dig down here and see whether, maybe it wasn't the result of overt, KKK style racism. We sadly in our system have these things embedded in the process that enable prosecutors to give in to their implicit biases and treat different defendants differently based on what on the surface appear to be non-racial factors.
I have a slightly different perspective. I just encourage everyone to also keep in mind the international perspective. And I think I'm not an expert on it, but I think if you look at countries like France, you look at countries like England, or to our south, Mexico, you'll see a lot of the same problems within the criminal justice system that we have here. What's different about the US, I think, is the scale. So my own feeling after all these years is that what the United States has done by putting 2 or 3 million people behind bars at any one time, by giving 20 million Americans a felony on their record, 70 million Americans a misdemeanor on their record, probably that would not be possible in another country. And that what made that tolerable was the idea, oh, it's primarily happening to people who are not like us. So there are parts of the American system that are distinctively racist. But if you look at these kinds of, how the police and prosecutors deal with violent crime, I think you see the same things throughout the world.
Hi, hello. My name is Jose Panvecchi, and I'm a 3L here. So it's no real secret that well, this case has gotten quite a lot of media attention. I wanted to ask, since y'all mentioned the culture at district attorneys' offices, as far as wanting to get convictions and also not really wanting to, like the instance in Brooklyn where you had the head of the CIU overseeing a case that he had himself tried. Do you think that the consequences for the prosecutors involved in this case would have been different had Judge Zayas not identified them by name?
Absolutely. Had Judge Zayas not been so blunt and vocal in his findings and the names not been put out there, there would have been no recourse. Everyone would have gone back to status quo. There would still be professors here. There would still be high-level executives in Nassau County District Attorney's Office, and no one would have been held accountable. Now, whether there'll be further accountability, we'll see, but no, I think there would be none.
I agree.
And the difference is simply seen because you can compare Queens to Kings County. Kings County has at least 25 major exonerations that the district attorney himself has consented to. But in terms of prosecutorial accountability inside the office, there really is none.
Well, the prosecutor in Jabbar's case, I mean, his actions were atrocious. And what did he do? He went on to remain a professor despite all of the media coverage and despite the Eastern District judge annihilating him publicly. So.
And look, sadly, the profession doesn't police itself. It
Right.
just doesn't. The disciplinary committee is going to do nothing about any of these cases. That's the sad reality. And, maybe that's something that you all should be thinking about when you join the ranks, how you can affect that kind of change.
Can I add one person that hasn't been mentioned at all is Bryce Benjet. Without Bryce Benjet and the Conviction Integrity Unit, who looked at this case and went everywhere with it, this never would have happened.
Absolutely.
Because lawyers can correct me if I'm wrong, but I don't think this case here went to appeal. It was just a series of negotiations between the lawyers and the DA. And it never got appealed, and they just did the right thing. Melinda Katz, it's a terrible price to pay to admit you did something, your office did something wrong. Because no matter which office it was, either it's under Brown or it's under Katz, it's the DA's office. They take the hit for it. And-
Sure. Sure. I can explain. Bryce Benjet was a defense attorney who did death penalty work. He was also in the Innocence Project. So he came from the defense world, working cases with immense amounts of misconduct. When Melinda Katz became DA, for those of us doing this work, we were waiting for a new DA in Queens. We were hoping for the day that the stars would align. When she became DA, she brought in Bryce Benjet to head up the Conviction Integrity Unit, which was a new unit for that district attorney's office because one did not exist. Prior administration's position was, we have no wrongful convictions. So Bryce started in 2020. We had already amassed all of our information. Tom had gotten his information. We started working with Bryce Benjet and submitting evidence to him, and he started a reinvestigation. We worked with him on that reinvestigation. There was a major collaboration that is unheard of. And in that collaboration, he unsealed files, he unsealed other relevant cases involving the Speed Stick gang, and started exchanging that information with us. And we would have Friday meetings and we would be like, like kids in a candy store. Oh my God, we got more documents today. We have more documents today. But it was that collaboration through the entire year of 2020 that this case started to take a turn.
But there's a very interesting anecdote that I'll tell here that's a little bit of inside baseball, and I won't mention any names, but during the pendency of this case down the home stretch, and David and Jabbar and Rita will remember this. There became a point where there was an argument because some of the attorneys on the call felt that Melinda Katz was moving too slowly, even though Bryce was, as Rita said, it was unprecedented what he was doing. But there were some attorneys on the call that thought, forget it. We have a great case. We have a great 440. Let's file. Let's just file. Forget them. And then there were other attorneys on the case, and I would argue they were the ones with the more criminal law experience that were saying, whoa, this has never happened before. We are in a situation where we have the head of the CIU working with us as he should be. And we have an opportunity to resolve this, as Pete just mentioned, without going through any legal process. And the problem with going through that legal process, as one or more of us shouted on one call during a not so happy strategy call, is that you can file that 440 and have the greatest 440 in the world. And this happens time and again. It happened to Jabbar 5 times before he got exonerated. And the judge just says no, and there were lawyers on that call that said, but it's the law. And we said, oh, it's the law. Oh, sorry. You're right. File the paper. Who cares? I hate to tell you guys, but the law, especially in the criminal justice world, does not always mean anything. Okay. So Bryce was such a phenomenal ally on this. And look, he had some major internal battles, I think. He's a guy coming from the innocence world. He's a defense attorney, never prosecuted a case in his life. And he's got inside the Queen's DA's office, which is the most old guard prosecutor's office in New York.
And he gets it.
And he's got to go and convince these people to turn stuff over. He's got to convince PD to turn stuff over. He had such an uphill battle, and yet he never stopped engaging with us. And it was truly inspirational.
Yes.
Good morning. My name is Carol Ashley. I'm a 1L, and I just, I guess I'm not completely sure of what the consequence was for the misconduct of the prosecutors, and the professor here, I assume, was fired. So can you just discuss that for me? I'm sorry.
The consequences were that they were named in a decision by Judge Zayas. But the real consequences were that they were allowed to resign from their high-level positions within their district attorney's office. And one was no longer a professor at this university.
And they kept their pensions.
And they kept their pensions. They'll go on to private practice. They will keep their license, and they will continue forward with their lives.
Exactly.
Exactly.
It's no secret that obviously, sorry, did anyone have it? Are you sure? That in our system today, reintegration isn't always the easiest. So Mr. Collins, how did you personally feel reintegration was for you? And all of you, how do you guys deal with reintegration of your clients and of everybody else that comes out of this system feeling a bit hopeless?
Right. I think my experience was far different from most exonerees. I had a beautiful, loving grandmother and a beautiful mom and a strong family who stood by me. I would pray with my grandmother every Sunday. So, and I refused to accept that this was my life. So even though I was in prison, in my mind, I was never a prisoner. And so I conducted myself in prison in the same way I'm conducting myself now. So I was ready for it, I think. And one of the benefits I had was that after my release, I went right into an environment that I was familiar with. I worked in law library when I was in prison. I started working in a law firm, and I would work from 8 o'clock in the morning to 8 o'clock at night. So it gave me the ability to adjust incrementally instead of, having all of this input in this new data being rushed upon me at one time. And I did it incrementally. So for me, I think I had a very smooth transition because I had always lived this way and had practiced this way inside. And unfortunately, it's not like that for many of the other guys. And I think that the hard part for me was while I was inside, getting up every day and convincing myself that there was still a reason to fight, and seeing those years tick by and seeing myself get older and my children grow up without me, and convincing myself that I wasn't deluding myself, that one day God would deliver me from this situation and I would be free. So because I developed that discipline inside, after you spend 16 years in prison, everything else is small. There's nothing out here that can be compared to going through something like that. So my transition was far easier than most people.
I think reintegration is, like Jabbar said, can often be very difficult. You're going from levels where clients, I had one client who would wait for every weekend and then all he wanted to do was walk. He just wanted to walk without being told when to stop, what line to stay in, where to go. And so he would have to spend every weekend in the mountains and just walk around. I had another guy that would call up and say, my God, this store has so many toothpaste and I don't know what to do. And, we would make light of it and be like, all right, well, buy the red one. It says Colgate, you're going to like it. To, being there for when your clients call you. I have a client that calls me at 6 a.m. one morning. He was having an absolute breakdown. And I think I spent 6 hours on the phone with him between that 3 hours that morning and then 3 hours later, just to help him get back into the swing of things. Some have families, some don't have families. Bell, Bolt, and Johnson have amazing families, and yet integration is tough. So and there's no resources. So I think that that's another part of our system that is seriously flawed.
George Bell had a wonderful line in an interview right after he got out. He talked about, it's poetic. He talked about how it was amazing to him that he could, and I'm going to mess this up, but that he could just get up in the middle of the night and go in and open the refrigerator.
That's right. You got it.
And that's it. And to me, I was like, oh my God, like that says it all right there.
Could I tell you folks a story that's a funny story? I think you'll like it. I'm up at Greenhaven, interviewing, talking to George Bell. Up there for a couple of hours. I don't take notice of anybody else in there, but there's a couple hundred people in that bullpen area. So when I leave, the fellow sitting behind me asked George who I was, and he tells him, oh, he's a nice guy. He's trying to help me with my case. But this is years ago. And he says, you think I could write him a letter? And he says, yeah, sure, write him a letter. What do you got to lose? So he gives him my address and everything. And the letter comes, and I open up the letter, and I'm reading the first paragraph where he's describing how he was arrested, picked up. Guess who arrested him? Me. And I got back to him and I told him, I didn't think you were guilty then. I never thought you were guilty, and I still don't think you were guilty. And then I wrote to the parole board. Eventually, he got paroled and he's out now. But I just think that's, part of this whole story that doesn't make any sense, that you can't present to a judge that you're right. I mean, how did these things happen? It was almost like God is up there directing you to go there, to sit there at that exact time and that exact place with a guy that you arrested for shooting a cop, no less. So just a lot of crazy things happen. Don't discount anything when you're doing your business. Just keep on looking. How'd you like that one?
Hi, my name is Kiro Ibrahim. I'm the 2L here. I have to preface this by saying I mean no disrespect to the former prosecutors in the room, any of you, but this question has been touched on. We've talked a lot at this school about systemic injustice and systemic racism, especially in the criminal system. And I don't think it's unfair to characterize that DA's offices are the primary delivery mechanism of these inequitable results. And as has been described by our panelists, this isn't a bad apple problem. This is a culture problem with DA's office, so much so that even today you've described individuals doing their job as they should as unprecedented or heroic for doing it as they should. So my question is, should this school, given the culture problems within DA's offices, be more skeptical about giving professorship positions to people who were formerly DAs?
No, you go first.
No, I don't think so. I think that, for example, I would love for Charles to be a professor here. I mean, so, you can't, the appellation, you can't just because they had the prosecutorial background, it really depends on the individual. If there, if there was a safety net, perhaps, you ask for a list of any prior cases that the prosecutor handled and, to do your due diligence, but absolutely not. I mean, they're an incredible prosecutor. Look, unfortunately, when you see these horrible cases and you do see the system, that doesn't mean that every prosecutor in that office took part in these prosecutions or are the bad apples in that office. So I would say absolutely not, because if I was a law school student, I would love to have a professor like Charles, who has the perspective from both a prosecutorial view and a defense view. So I wouldn't summarily dismiss everyone just simply because they had a prosecutorial background. No.
Let me jump in on that one. Being less of a statesman. I would compare it to the situation that we have with judges at the state and federal level who have been stocked for decades now with former prosecutors, both the federal and here in New York State. The New York Court of Appeals has virtually never had anyone with a defense perspective on their court, and that was a major source of debate when the most recent judges were named by Governor Cuomo. So I would just compare it in that sense. And for me, prosecutors have pretty much had the run of the law schools and the judges for a long time. And I would compare it to the efforts by President Biden now, who's actually nominating defenders, including a colleague of mine from the state direct appeal system at the Office of the Appellate Defender, to be a federal circuit judge, which is basically unprecedented in the United States. So I would say, think about those things as they apply to the law school. And also just the idea that of there being a defense ghetto within law schools, that, there's in many law schools, you'll see a very gung-ho defense world, but it tends to be some subset of the students. And so I just make a shout out, as we were talking about earlier, diversity in experience, something more from the English model, where lawyers who handle criminal cases professionally do both prosecution and defense function throughout their careers. Those are, to me, two very important ideas.
Yeah.
My name is Kalechi Alfredi Bokwe. I'm a 3L at St. John's. My major question right now is that we've spoken a lot about the innocent men who went through egregious violations of their constitutional rights. I wanted to know about your experience with the violations of constitutional due process for men that are women and people in general who are also purportedly guilty. Like, what does that mean to you? What do you expect in terms of the standards, even for people who are guilty? Because I think that is the major issue in the criminal justice system, because as we are cutting corners of people that are guilty and still disrespecting their constitutional rights, that's how we end up with innocent people that go to jail unfairly.
Would you mind just repeating a little louder? I
Yes.
think
Yeah.
I know with the mask, it's hard. Sorry.
Yes, I was just saying, what is your experience with people who are guilty and their violations of their constitutional rights in that aspect?
Are you asking about people who plead guilty versus being convicted? Sorry.
Essentially, throughout the way from pre-trial to sentencing.
Well, I mean, in the defense work that I do and have done, for the clients where you kind of have evidence that's just dead to rights, your goal is to, one, ensure that their rights are still protected. And oftentimes they do plead guilty. Oftentimes you are working out a way to give them
whether it's, help, put them in some program. So it's not just the lock them up and then throw away the key until they come out later on. You're working towards ensuring that whatever plea they're taking will ultimately help them in some fashion. So
The
I think-
problem is far too often the guilty plea is used as a weapon by unscrupulous prosecutors because they have caseloads that are too big and they, to get back to the disposable thing, they don't particularly care that they may be forcing someone to take a plea deal that they're only taking because they don't want to go to jail for longer or they don't want to go to jail, period.
Or they can't risk a trial. So
Yeah.
you'll have somebody where, like in Queens, the policy, coming back to policy, the policy is if you don't take a deal before you're indicted, then the deal's off the table. Now, who the heck heard of that? Because you don't even know what evidence they have against you to make an informed decision. So if you're running against the clock of being indicted, your client will be like, well, let me just take a deal. If they're giving me 2 years or 5 years after indictment, I'm going to have to, plead to the top count. And now I could be going away for 15 years.
Right.
And so they have to think about, I don't have the money, I don't have the family support, or my family can't handle this. I could do 5 years, Rita. I can't do 15. You know
That's
what?
right.
Get me the 5 and let me just be done. And so you're
yeah.
dealing away lives.
The past couple of questions, I think, are highlighting something that's very important here, which is how, the previous gentleman talking about prosecutors and whether they should be teaching in law schools. And I think Jabbar's right that we're talking about, thankfully, I think a minority of prosecutors, but even a sizable minority is a huge problem. And I think we need to be thinking really creatively about how we change the culture of DA's offices to fix these problems internally, like not doing things like that, where you don't get a second chance at a plea bargain if you don't take it the first time. Or the one that I particularly hate is if you testify in the grand jury, there's no deal. Everything's off the table.
Right.
And one thing that I frequently am sort of banging my hand on the table about is I don't understand how in today's criminal justice world, when you have so far fewer, even in the last year, you have so many fewer criminal cases, the caseloads are so down. When I was a rookie DA, I carried 150 cases at once. Now they probably have 50, right? So there's less serious crime. So why don't we have a setup where instead of reviewing cases 25 years later and getting guys out of prison after a quarter of a century in prison, why don't we do a look back at the time that they're indicted? Okay, like Central Park 5. If you had a parallel panel of prosecutors, maybe prosecutors from a corruption unit, to look back at the evidence in advance of indictment, they would have said, hey, Linda, pump the brakes. You guys don't have what you think you have here. And unless you can get this case up to standard, you're not going into the grand jury. We could prevent this stuff at the outset instead of litigating it 25 years later after people's lives have been ruined or nearly ruined. There are a lot of cultural things that you could do internally in DA's offices to fix these problems.
If I could just add one more thing. I do appreciate your question, as I take it to be the question about how does the system work for cases where innocence is not the front and center?
Yes, thank you.
Yeah, so, for me, I talked for, the reason that innocence cases get such intense scrutiny is because everyone is interested in them. And so the defense bar has really tried to use them to drive discussion about all of the issues in the system. For years, I would try to pitch stories about guys who had had horrible lawyers, lawyers who fell asleep at the table, lawyers who didn't do mitigation for someone who was guilty, but maybe they should have had a lesser sentence, or it was a lesser degree of the crime. These are things that drive defense lawyers every day. Something happened, something bad happened. What is the grade of the offense? What is the appropriate response? And I would talk about these cases with everybody I knew, and only other criminal defense lawyers would really respond when I said, you got convicted of manslaughter 1, but this was really a reckless. It should have been man 2. And then when the DNA cases came along in the 90s, the debate just exploded. And then the concept of mass incarceration came along and it exploded again. So we're really trying to use those two platforms as a way to examine everything that goes on within this gigantic criminal legal system.
I
think we-
appreciate all your answers. Thank you very much.
Oh, thank you. I think we have time for one more question. Was there one more over here? Yeah, go ahead, Ryan.
How's it going, Ryan? I'm a 3L. So police, prosecutors, law schools, prisons, big businesses that use prison labor all benefit from this misconduct. How would you suggest we reduce, interfere with, or replace these incentives?
We've done a lot of litigation in this area regarding prosecutorial accountability. And I think the main area that you could reform it is by actually prosecuting those prosecutors who take away and destroy people's lives, like Larry Krasner has just done when he indicted those police officers in Philadelphia. If a prosecutor knew that if he used perjured testimony at trial, if he's found to have committed misconduct and sent a man away to prison for 10 years, if he knew that he would face 10 years in prison himself, I think it would change the dynamic. I think all of a sudden you would have the most honest prosecutors you've seen, in the country. So I think if there was truly repercussions for this type of misconduct, that would change the playing field.
Yeah, in a case like this, the conduct is so egregious that I definitely agree that that should be on the table. But I think you could even just start, we talked about the disciplinary committees before, just start with a real threat to the law license.
That's right.
That's the lifeblood for all attorneys. And
Right.
if you think that there's a good chance that you're going to lose your law license if you engage in this kind of conduct, you're not going to engage in this kind of conduct.
I think it has to be financial as well. I think that you should also, there has to be a loss of your pension. You accrued what
Definitely.
you did by doing what you did. If you lose your license, other than the blight on your record, you can find something else to do. You will find something else to do, or you will live off that pension. But if there is real liability for your actions, and now you will lose your money, then I think that will also send home a message.
And look, this is a little, for lawyers, that's absolutely possible.
Right.
The really frustrating thing about prosecuting dirty police officers is that you almost can never get at that pension unless you actually convict the cop, which is, cop cases are difficult cases. And I could sit around and tell you guys about video evidence of someone getting beat half to death for 10 minutes on camera and the cop does not get convicted. So, but you cannot, the unions are a big problem, especially the police unions, and you cannot get a cop off the job, never mind get his pension, without making it all the way.
And if I can add one more comment, in civil litigation, there's a doctrine called prosecutorial immunity, which holds that even if a prosecutor, for example, the prosecutors in this case, as so long as they committed this misconduct in the pursuit of their trial duties, they're absolutely immune from civil damages, which means they can't be sued personally and held liable. So the only way you could sue those was by suing the city and to get derivative liability. So if there can be an exception to prosecutorial misconduct for intentional misconduct, I think that would have the same effect too.
There has to be punishment. There has to be some form of punishment, whether they're lying and they're cheating. If it can send us to jail, then it can send them to jail. They should be held to the same standards, and that is what's missing.
Thank you. Thank you all so much. This has been so much rich information about systemic and individual injustice, the roles of attorneys and so many other people involved in that journey to justice. And we are so appreciative of your time. So I'd like to thank Charles and David and Jabbar and Rita and Peter, please. Professor Chu started us off by thanking everyone, but I want to thank Professor Chu too, who really made this all happen. So thank you so much. And I want to thank one more group of people who are so instrumental. all of you students. Thank you. Thank you for what you do. Thank you for making our jobs possible. Thank you for holding us accountable. And please continue to do so. Continue to fight, like Rita said. And if you need advice about how to find the fortitude to do so, I think Rita is offering some. So thank you all very much. We appreciate your presence.
I could